On the bottom, lower right, please. On the bottom, lower right, please. Thank you. Come on, everyone. Come on. Sir, please work. Excuse me, down. Okay, I'll go then. Thank you. Hold the department. Thank you. One. Okay. Thank you. Good morning. Phone call, go away. Thank you.
Quiet, please. Jury's all rise, please. J. All persons having any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, before the County of Norfolk. Your name, give your attendance, you shall be heard. I say the Commonwealth of Massachusetts, the court is now open. Jurors remain standing. All of the party may be seated.
Jurors, can I have each of you raise your right hands? Do you solemnly swear to make true answers to such questions as you put forth to you by the court, so help you God? Thank you. You can have a seat. May I call the case, Your Honor?
Please.
Judge, this is 2282 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Leslie on behalf of the three.
Good morning, Mr. Alessi.
Good morning, Your Honor. For Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, good morning, jurors. My name is Beverly Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on how we think your day is going to shape up. As you've heard, we're impaneling a criminal case, Commonwealth versus Karen Reed. But before we begin, I want to thank you for your service here today and for your patience. Jury service is certainly one of the most important duties we have as citizens, and we simply couldn't work without you. The system would fail. So we really appreciate that you're here, ready, willing, and able to serve if called upon to do so. Now, in this case, the Commonwealth alleges that at approximately 6 a.m. on January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to his residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he subsequently was pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. Ms. Reed denies these allegations. She is presumed to be innocent and has pled not guilty. Ms. Reed is charged with second-degree murder. The defendant is also charged with manslaughter while operating a motor vehicle under the influence and leaving the scene after causing personal injury or death. I'll describe these crimes in greater detail at the end of the case when I teach the jury the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder, and that murder was murder in the second degree. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that in the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all in this case. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you a series of questions as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have each one of you come up to the sidebar one at a time so that we can follow up with you on your answers to that questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you will be excused during the impanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps picked on another case. In a few minutes, I'll pose a number of questions to you as a group, and you've taken an oath that requires you to truthfully answer those questions and all questions posed to you. I'm not going to ask you to take out your juror cards yet. I'll ask you to do that at a later time. But if your answer is yes to any of the questions that I ask, at that time, I'll ask you to raise your hand and you'll hold up your juror card in the air with the numbers facing out so that the court officer can read it. The fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that the lawyers and I need to discuss with you at sidebar. If you find a question posed to the group overly intrusive, you may elect to answer that at sidebar as well. I will have additional questions for you which relate to the issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror, and the lawyers are permitted to ask you questions for the same purpose. This is not a test. There is no right or wrong answer. We're simply looking for your best and honest answer to the question. I'm now going to ask the lawyers to introduce you, and I'm going to ask counsel for Ms. Reed to introduce your client.
May I, Your Honor?
Please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. I appreciate you being here. I'd like you to meet my colleagues.
Good morning, my name is Laura McLaughlin. I'm an assistant district attorney for the Norfolk District Attorney's Office. I thank you for being here this morning.
Morning, ladies and gentlemen. My name is Adam Lauer, Assistant District Attorney with the Norfolk County District Attorney's Office. I just want to thank you again for your time and attention today.
All right, thank you. Mr. Jackson?
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Alan Jackson. I have the honor and privilege of representing Ms. Karen Reed, who's standing to my right.
Good morning, ladies and gentlemen. My name is Elizabeth Little, and I also have the honor of representing Ms.
Good morning. My name is Robert Alessi. Thank you for being here today. I have the privilege of representing Ms. Reed.
Good morning. My name is David Yannetti. I'm an attorney. I have offices in Boston and right here in Dedham, and it is truly my pleasure to represent Karen Reed.
Good morning, everyone. My name is Victoria George, and I also have the privilege of representing Ms. Reed.
Good morning, I'm Karen Reed.
All right, thank you. Jurors, I'm going to read you a witness list. It's very long. It does not mean that every person whose name I called will be called as a witness. It means that some of the folks whose names are on this list are just people you may hear about during the trial. I'd ask that you pay close attention to these names because in a little while I'm going to ask you folks if you know any of these people. The list is alphabetical, but it's alphabetical by first name. Aidan Kearney, who is from Jefferson, Mass. Dr. Isaac Wolf from South Miami, Florida. Alfredo Lopalato from Canton. Allison McCabe, Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, who's a PhD from Pittsburgh, Pennsylvania. Angela Malvone from Canton. Annie Chung from Canton. Anthony Flamati, who is with the Canton Fire Department. Ashley Bell from Canton, Ashley Valier from the State Police Crime Lab, Brian Albert, Norwood, Brian Albert Jr., Boston, Brian Higgins, Sandwich, Brian Loughran from Canton, Brian Wanless, who is retired from the Canton Police Department, Bridget Meehan, who is keeper of the records in Canton, Caitlin Albert, Easton, Lieutenant Charles Ray from the Canton Police Department, the Chief of the Canton Police Department, Helena Rafferty, Chris Van E., who is a PhD from Novi, Michigan, Christina Hanley from the Mass State Police, Christopher Albert, Canton, Christopher Curran, Canton, Colleen Crawford from the Norfolk District Attorney's Office, Colin Albert, Canton, Courtney Proctor, Canton, Kurt Roberts, Canton, Daniel Whitley from the Canton Fire Department, Daniel Wolf, who is a PhD from Penns Park, Pennsylvania, Derek Ellington from Wake Forest, North Carolina, Dr. Marie Russell from Los Angeles, Dr. Elizabeth Lopesada, who is from Providence, Elizabeth Proctor, Canton, Eric Hanlon, Canton, Erin Beatty, Canton, Erin O'Keefe from West Bridgewater, Francis Walsh from the Canton Fire Department, Garrett Wing from Green Cove Springs, Florida, Gary Fowler from Brockton, Gregory Woodbury from the Canton Fire Department, Gretchen Voss, Boston, Hannah Knowles from the State Police Crime Lab, Heather Maxson from Walpole, Erabito Hernandez from the Boston Police Department, Holly Price from Mountain View, California, Ian Whiffen from Vienna, Virginia, Dr. Irene Scorti Bello, who is with the Chief Medical Examiner's Office in Massachusetts, James Crosby, who is a PhD from Jacksonville, Florida, Janet Reed from Dighton, Jason Becker from the Canton Fire Department, Jean DeMoulis from Canton, Jennifer McCabe, Canton, Jessica Hyde from Bridgeport, New York, John O'Keefe Sr., who lives in Braintree, Judson Welcher, who's a PhD with a company called Aperture, LLC, Julie Albert, Canton, Julie Nagel, Canton, Dr. Justin Rice from South Weymouth. There are two juveniles who may be witnesses in this case. They both are from Canton, and the first one's initials are KF, and the second one's initials are PF. Caitlin Boudreau from Raynham, Karina Kolakithas, Canton, Katie Camerano, Canton, Katie McLaughlin from the Canton Fire Department. Keeper of the records for Ring from Hawthorne, California, Kerry Curran, Canton, Kerry Roberts, Canton, Kevin Albert, Canton, Kevin O'Hara from the Mass State Police, Lance Mello from the State Police Crime Lab, Laura Sullivan, Pembroke, Laurie Cahill, Worcester, Leslie Pearlstein, Canton, Lieutenant Michael Lank from the Canton Police Department, Louis Jutras, Canton, Lieutenant Brian Tully and Lieutenant John Fanning, both from the Massachusetts State Police, Lieutenant Paul Gallagher, Canton Police Department, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato from Canton, Margaret O'Keefe from Canton, Marietta Sullivan, Pembroke, Mary Souza, Dighton, Matthew Amory, Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly from the Canton Fire Department, Matthew Kelsch from the FBI, Matthew McCabe, Canton, Maureen Harnett from the State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano, Canton, Michael Easter, Los Angeles, Michael Trotter from the Canton Public Works Department, Michael Wagner, Foxborough, Mike Meroli, from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Wyweek Berschneider from San Marino, California, Nathan Reed, Raynham, Nicholas Bradford, Lorton, Virginia, Nicholas Curran, West Roxbury, Nicholas Kolokithis, Canton, Nicole Albert, Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty, Somerset, Paul Makowski from Melrose, Paul O'Keefe from Canton, Rebecca Bazin, Canton, Rebecca Trayers from Norfolk, Dr. Renee Stonebridge, who is also from the Office of the Chief Medical Examiner in Boston, Richard Green, St. Pete Beach, Florida, Richard Donato from Canton, Robert Gilman from Hull, Ryan Nagel, Canton, Sarah Levinson, Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul D. Giampetro, Canton Police Department, Sergeant Yuri Buchanan from the Mass State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the State Police Crime Lab, Stephanie Devlin, also from the Crime Lab, Stephen Mullaney, Canton Police Department, Steve Nelson from the Norfolk County DA's office, Stephen Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge, Boston Police Department, Stephen Seraph, Canton Police Department, Stephen Scanlon, West Roxbury, Terry Kuhn, who is from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty from Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton. The following are Massachusetts State Police troopers: Trooper Connor Keefe, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, and William Reed from North Dighton, Mass. So there are a lot of witnesses, so you know that this is going to be a long trial. We're in the process of impaneling a jury. We began a while ago and we're getting close. So I don't know when we will get a jury, but once we get a jury, when we start the evidence, I am told by the lawyers that the evidence is expected to take 6 to 8 weeks. After that, you'll hear the lawyers on closing arguments. I will instruct you on the law, and the jury will begin deliberations. And the jury can deliberate for as long as they need to deliberate. So that's our schedule, our time schedule. It is a good faith estimate. Sometimes cases go longer, sometimes they're shorter. What I can tell you is at every jury trial, at the end of the day, I tell the jurors whether we are on track, whether we are ahead of schedule, or whether we're behind schedule. And I have not had to say that we are behind schedule, I think, ever. So we make every effort to make the best use of your time because we know how important your time is to you. The daily schedule will be that we'll start at 9 o'clock in the morning. We'll take a break for about 15 or 20 minutes, sometime around 11 o'clock. Then we'll break for lunch sometime around 1 o'clock. Lunch will be brought in for you folks every day. Again, it's an effort to make efficient use of your time so you don't have to walk down to the center and come back. The luncheon break will be about 30, 40 minutes each day, and then we'll go until about 4 o'clock in the afternoon. If we go any later, I always ask the jury if it's okay with them if we go later. So the latest we would go would be 4:30 if we wanted to finish up a witness. So that's our schedule. There will be a few days and few half days in there sprinkled throughout, and I'll give those dates to the seated jurors at the time. So that's the schedule we'll be working from. Now, it might help if I give you a preview now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law at the end of the case, but for now, I'll give you a very brief summary of some very important constitutional principles that will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. An indictment is a formal manner of bringing a case of a person accused of a crime before the superior court in this case. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the jury, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it at all in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in a case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage. Please don't worry about it, because you'll be in a better position to understand this at the end of the case when you've heard the evidence and when I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it to you. So for jury selection, it's important to know if any of you might have some doubts whether you can accept and follow these legal principles. So now's a good time to take out your card, because I'm going to start asking you questions in a minute. So if your answer is yes to any question, I'd ask that you raise your hand. But before we begin, I understand that sometimes jurors do not fill out the questionnaires completely. Sometimes we're just in a hurry to get those forms back in, or we think that our situation doesn't apply to the question being asked, or sometimes we simply forget to put something on there. If the lawyers or I see that there's something that's missing, we will ask you. But if you're sitting here now and you realize that you maybe didn't include prior work history or prior involvement with the courts as a defendant in a criminal case, as a witness to a case, as a juror, anything that you know that you didn't include, I would ask that you tell us at sidebar. And if we see something, what happens with some frequency is people forget to put their age on there. We have to ask you because we have to keep a record. All right, so my first question. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses? If so, please raise your hand.
1083 1108
1127 1115
1122 1086 1114 1093 1100.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the lawyers or the Norfolk County District Attorney's Office? If so, please raise your hand.
1100 1114 1086 1108.
Thank you. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome? I see no affirmative responses. I'm going to ask you to raise your hand if you have seen, heard, or read, or talked about this case.
One, 136, 1198, 1098, my apologies. 1068, 1090, 1120, 1082, 1109, 1138, 1075, 1108, 1125, 1063, 1091, 1134, 1087, 1131, 1102, 1106, 1137, 1083, 1088, 1079, 1097, 1123, 1122, 1080, 1086, 1114, 1092, 1072, 1141, 1139, 1093, 1140, 1066,
1107, 1085, 1127, 1119, 1115, 1112, 1121, 1096.
Thank you. Please raise your hand if you have formed or expressed an opinion in this case.
1136, 1098, 1068, 1090, 1120, 1082, 1109, 1138, 1075, 1108, 1063, 1131, and 1083. 1097, 1122, 1086, 1072, 1093, 1140, 1066,
1107, 1085, 1115, 1112, 1121, 1096.
Thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If so, please raise your hand now.
1131, 1120, 1068, 1108, 1097, 1093, 1140,
1085.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
1068, 1073, 1142. 1078.
Could you say that one again?
Last one?
Yes,
1078.
thank you.
1103, 1129.
Thank you. Do any of you folks have any difficulty understanding or following those very important constitutional rights that I told you about? First, that the burden of proof rests entirely with the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She doesn't have to testify. She doesn't have to put on any evidence. All she needs to do is show up for the trial. Is there anyone that would have any difficulty applying those very important constitutional principles? I see no affirmative responses. I can tell you folks that after every jury trial, I go in and I talk to the jurors. And though they may not have been thrilled about having jury duty when they walked in for the first time, by the end of the trial, there have been people on every single jury that have told me that they found their experience to be an interesting one. And many people have told me that they've also found it to be a rewarding one. But I do understand that for some of you sitting on this jury could be a substantial hardship. And let me tell you what I mean by that. Every civic duty we have causes us to be inconvenienced. What we're talking about here is something much greater. It means that it's something personal to you. That means that I excuse you and the person next to you has to take your spot. I generally think of it in terms of you have airline tickets or surgery scheduled for the time that we will be on trial. But I will hear from anyone who thinks they have a substantial hardship. If that's you, please raise your hand.
1136, 1098, 1131, 1073, 1134, 1090, 1091, 1109, 1063, 1070, 1075, 1108, 1083, 1092, 1080, 1072, 1141, 1139, 1093, 1111, 1066, 1140.
1115, 1121, 1096.
All right, thank you very much. I am going to leave the bench in a minute to give you a chance to fill out those supplemental questionnaires that will be provided. I'd ask that you not talk to anybody about those questionnaires, that you don't talk about your answers, you don't talk about any questions or concerns that you might have about jury duty, either in general or in particular to this case. If you have any questions or concerns, please bring them up when you come to see me. Again, I thank you for your patience, and we'll see you in a while.
All rise for the court, please.
Thank you. You be seated.